everyone. I'm going to report about the case of Philippine Association of Service Exporters versus Honorable Franklin Drilon, GR number 81958, dated June 30, 1988. Now, this case talks about Department Order Number 1, Series of 1988 of the Department of Labor and Employment, in the character of guidelines governing the temporary suspension of deployment of Filipino domestic and household workers. The facts of the case: the petitioner, Pasei, is a firm engaged principally in the recruitment of Filipino workers, male and female, for overseas placement, challenges the constitutional validity of Department Order Number 1, Series of 1988 of the Department of Labor and Employment. Their contention was that it is a, first, discrimination against males or females. Second, that it does not apply to all Filipino workers but only to domestic helpers and females with similar skills. Third, and that it is violative of the constitutional right to travel. On 1988, the Solicitor General filed a comment informing the court that the deployment ban in the states of Iraq, Jordan, Qatar, Canada, Hong Kong, United States, Italy, Norway, Austria, and Switzerland has been lifted. Then the Solicitor General invokes the police power of the Philippine state. Now, the issue in this case is whether or not DO number 1 is unconstitutional, it being an invalid exercise of the lawmaking power since police power is legislative and not executive in nature. Ruled that it is not unconstitutional because the concept of police power is well established in this jurisdiction. It has been defined as the state authority to enact legislation that may interfere with personal liberty or property in order to promote the general welfare. And it consists of, first, an imposition of restraint upon liberty or property. Second, in order to foster the common good, it is not capable of an exact definition but has been purposely veiled in general terms to underscore its all-comprehensive embrace. So no merit in the contention that Department Order Number 1 constitutes an invalid exercise of legislative power. It is true that police power is the domain of the legislature, but it does not mean that such an authority may not be lawfully delegated. In view of the foregoing, the petition was dismissed, no costs. Daghang salamat, kanunay kitang mag-amping ug maayong gabi kanatong tanan.